the law is right on a number of authorities, including the case of Honourable against the FRA, so that when an application of this nature is brought before the Court of Appeal, which in substance will determine when determined or allowed, we terminate the entire proceeding before the court. Some 2 or 3 OCs will not apply, and the court should stay proceedings. We have established laws and other authorities will supply to the court. However, the court also found for us, and also after the submission by Lead Counsel with Mike Ozekhome, the court stayed proceeding in the matter and adjourned the case to 14th of November 2017 for mention. Now, the court said ordinarily the matter should have been adjourned sine die. The court said it's mainly coming up on that day for court to ascertain the level of progress of the case in Court of Appeal. And we'll have some conviction and belief that we'll get justice in Court of Appeal, and more especially when the extant party direction of Court of Appeal enable appeal of this nature to be heard speedily. So I believe the case is settled, and we are sure that it can be heard speedily, and hopefully that we will get justice in Court of Appeal. And when the appeal is allowed, then we can walk home straight from wherever he is and walk home. So, because it's high time we try the upper court in view of the antecedents in this court. Without prejudice to my lord, actually I'm not saying it's not competent, but what I'm saying that it's high time we have a bite in the upper court. So that's actually what happened today. And state of proceedings in effect, I need to explain this. Well, other people have asking us what state of proceedings entail. What it entails is that, or what it means is that the court, Honourable Justice, Lordship, my Lord Honourable Justice Nyako, will not take further step in this case again. Meaning that he will not adjudicate on this case, pending when the Court of Appeal hear our appeal and rule upon it. So the fact that it's adjourned to 14th of November does not mean that the matter is coming up for any activities on that day. It's just coming up for us to report to the court that the Court of Appeal has had this appeal, adjourned for ruling, or they have ruled and delivered judgment and dismissed the charge, and now the case is longer in the court. They have left the detention facility where it's been detained. So that's what it means in effect. So thank you so much.
Yeah, thank you very much, Barrister. Considering the principle of natural justice, the procedural fairness, so and so as you have put forward, could it be said, judging by what document you have put forward, that your team filed the application following your client's disappearance, Mazi Nnamdi Kanu, on sometime in April 2019? Could it be said that your team has been robbed off, or could it be said on the other hand that the principle of natural justice or the ultimate partem has not played out in this case?
No, not for this ruling, but the ruling of the court delivered on the 28th of March 2019. We are not given opportunity to be heard.
Yes.
Pursuant to which we filed an application for him to set aside the order he made without jurisdiction. So, because you see, we're talking about something fundamental, and I believe I've stated this thing in many forums. You see, we're talking about the fact that Nnamdi Kanu is alive today. Let us face the reality of life. Just like what happened to me on several occasions. Assuming Nnamdi Kanu, Onyendu Mazi Nnamdi Kanu was killed on 14th of September 2017, when the Nigerian military invaded his premises, killed over 28 persons there. We were talking about this charge. The answer is no. See, so it shouldn't be treated with a wave of hands. The court is under compelling obligation to look at the fact before him, to look at what you are saying, to look at evidence before the court, to look at what Nnamdi deposed on oath, or Mazi deposed on oath, understand what happened in his house. This is very fundamental. It can't be treated with a wave of hands. We're talking about somebody's life. Okay, up to today, nobody has said anything about the 28 persons that were killed in his genocidal massacre in his home on 28th of September 2017. What offense have they committed? These are people who are unarmed, civilians, and they were killed in the cold blood. So what are we talking about? Assuming Onyendu Mazi Nnamdi was killed on 14th of September, will we be talking about this charge today? The answer is no. The answer is capital no. But God has been keeping him alive. And the court is on this is a person I granted bail. I granted him bail. And we took him on pretrial conference before then. And he was ready to be in court. And in one of the meetings he had with some people, he made it known to the public that he's coming to court on the 11th of October with over 1 million persons, supporters, to come to court with him. I can say this and I can beat my head, I can swear with my life that Onyendu Mazi Nnamdi Kanu was prepared to come to court on October 2017 before this thing happened. I can swear bet my life for that. Because I took him on pretrial trial conference. We are ready for the matter, because we know they have no charge against him. They have no case against him. So why did you take what to his house? Even the law allows you, the stand laws allows you to arrest him upon being in court on that day. If you had wanted him there, if you wanted him to be alive, you are waiting for him to come to court. And upon conclusion of his case, you arrest him. And probably prefer for a charge against him. It's allowed. Why going to his service to kill him? So we're talking about this because he's alive today. So this matter should be treated with a wave of hands or limit. So we're not comfortable with the way and manner or the weight attached to what we file in court, per se. Because from the ruling of the court, obviously the court didn't look at what's before her. Today, obviously, he didn't mention the fact that the evidence before her, this evidence deposed to Nnamdi Kanu. Let me show it to you. Because it's important for you to be on the know about what happened. This evidence of file deposed to Nnamdi Kanu. See it. State of Israel. See it. He deposed this affidavit when he was in the state of Israel. Before not republic. Stating clearly what happened in his house. So this is a compelling document the court will look at it and make definite findings on them. But it wasn't mentioned today. Usually. So you see, we're talking about life, fairness and equity and justice. So where is justice? So I can assure you we are more comfortable going to court of appeal. Don't see it as we are playing with time. No. They are not serious about the trial. So let us go to the court of law and sort out the remaining thing. We won't be coming here every day and be taking adjournment. Of course, they're ready. Assuming we're not in court of appeal today, the matter will not go on to, of course, you know. They will adjourn the matter after vacation, probably sometime in September or November or October. We'll come back on October. There's something will happen again. They'll adjourn it to next year March. So take it seriously. They'll adjourn to next year March. And from next year March, they will say, okay, after election, 2025. This is Nigerian, pure Nigerian judicial practice for you. So we come appeal, and it's more so when we have enabling law. Court appeal practice, factual direction. Allow this matter to be had quickly. So we're a better place to be in court appeal. So don't see it as if we're taking time, we're playing with time. It's something good that happened today. Because I can assure you 100%, if you had proceeded today, the matter will not go on. These people are not ready to go on. They will file a further charge and serve probably this adjustment. But when you come back on September, they will have a further charge. They will file probably another 7 count charge or 6 and serve us. And we'll start afresh. So these are compelling facts and documents. His Lordship, we're going to file appeal against the ruling of today, of course. We have to notify to the public. So his Lordship has to look at it. And the court of appeal should look at it. You can't be talking about somebody's attempted murder on somebody. Then, and in the process, people were killed in premises. And he posted this furnish affidavit. Look at it. Very compelling document. How many paragraphs, how many pages? See it. Well detailed. See it. And the court didn't make any single pronouncement on it today. No pronouncement whatsoever. No reform was made to this document before the court. Filed since first day of April 2019. Are you telling me that they are planned, that they didn't see it? In fairness, this is what was filed before the court. And it was identified at the point of taking the application. It was identified before his Lordship. And it was filed on 1st of April. You can't move at this application without identifying that it was filed and dated. It's an elementary part of this practice. That when you are taking an application before the court, you must identify the state the date was filed, state it was dated. And it was clearly stated in court record. So why are you telling me it was filed 4 years after? Thank you so much for coming.
We should be by default 2 years. 2 years.
I don't know. What you say it took us almost 4 years to bring this application.
Okay, but before we go, I just want to be in the know, following the state of proceedings from the stable of Justice Binta Nyako and their version to the 3 headsmen in the appellate court. Does it happen to touch only the bail application or the counts in its entirety?
No, we're talking about in the appeal that the one has been entered. We're talking about a remaining 7 count charge, which are in all fours with the 8 count charge that we are struck out. they have the same facts, the same circumstance, the same drafting method, the same story. So you can't distinguish between the one that was struck out and the one that was left. So, and the grounds upon which they were being challenged, the entire thing counter we are being challenged, is the grounds upon which the remaining seven returned by court also being challenged. So we are urging the court of appeal to also look beyond that and dispute the entire counter. We have done it in several criminal cases, and we believe that that will get justice there too. We are going to appeal again this one too. For the sake of clarity, we understand that court of appeal, that Federal High Court, Umuahia, has already ruled on civil application brought before the courts for fundamental right enforcement of our client, Onyendu Mazi Nnamdi Kanu, for invasion of his premises and also the genocidal massacre of 28 persons in his premises. So, and the court found against the federal government that they grossly violated his fundamental right by the invasion and also killings hearing and made foundation pronouncement, gave order for compensation and also for public apology. So, however, my lord, when that was brought to the attention of my lordship, Honourable Justice Binta Nyako, he said that he observed in open court when application for his bail was moved, that even when this application was moved, that the purport of the rule of the State High Court Omaha was to sit on appeal against her judgment, that she's not binding by that judgment of the court. That was the thing. But it's a judgment of the court, and which the federal government has not been obeyed. It's a court set up by the government. No matter how stupid, as many call it stupid, the order of court is, we must obey that order. So as I speak to you, the federal government of Nigeria, ably led by President Buhari, are in contempt of court's judgment. They are in contempt of court's order. Because court said gave the entire willing wish to apologize. The court gave the entire willing wish to pay compensation, and they've not done that. So, and that settles the issue of jumping bail. So, which is imparamaterial with what we stated in the available support of this application.
Yes. More importantly, Barrister, speaking about bail application, because we understand that the main ingredient in the application, the bail application, is tilting towards health grounds of your client, Mazi Nnamdi Kanu. We just want to know, what is the latest development furthering his health now? Because it is only one who is alive stands trial. How is he?
Well, the point that what I want to tell you at this point in time is that we have a situation in this case that is becoming overwhelming. And it's important for us to let the public know. We have had cause to file several initiate contempt proceedings against the detention of facility, detention authority, and all those applications ends in this court. We have cause to file from 48. You know, when you're initiating contempt proceedings, you have to file from 48. Notice of consequences of the evidence to court order. And it was decided by the of the court. And Federal High Court registrar here in Abuja told us point blank that we cannot sign it. Not once, not twice. We are wasting our time. We should go back to court and resolve our problem. They cannot sign it. So when court made an order, we cannot enforce it. You see our predicament. So what are we doing here? Order that court made in open court that Nnamdi Kanu is entitled to have a medical practitioner to re-examine him for second opinion. The court made an order about the clothes, changing of his clothing. We send them today. Even in open court, the court made an order, take it to the facility, let him change it. Where are the clothes? It's not made in open court.
Yes.
So we have a number of orders this court has made. In fact, I even pity my Lord. And I'm just making order in the vacuum, nobody's obeying it. So this is a predicament to find ourselves. So what are we doing? So we should be clapping that we are living there to court of appeal. Because that's the most important thing. Okay. Believe me, I'm happy.
Yes.
Because it's possible that even the court will grant him bail today, they will not even leave him. Mark my word, it's possible that if the court has met more than 10 orders in the past, and they cannot even obey one, then how are you sure that even the court, if the court has vacated this order, revoking his bail, or issuing bail warrants against him, that they obey it? They will not obey it. So this is the point. So let's go there. Let's go there when we have 3 people. So they will review it. So let me see where court of appeal will make an order and they'll not obey it. So it's been on. So he's managing his house. He's understanding the predicament to find ourselves. We kept on encouraging him. Of course, we heard from him today. He knows what's going on. We meet with him every Monday and Thursdays. But this place will come to pass. You were here when President Buhari granted press conference last week, granted the press interview. During his title during the bilateral meeting, the Commonwealth head of state meeting. He told them, he categorically told the previous prime minister, Nnamdi Kanu was sometime in the past granted bail. This is a matter before the court. Granted bail and a jump bail. How are you sure that if it's granted bail again, he will not jump bail? Are you getting the language? Are you getting the statement?
And that is the executive.
Are you getting
towards the
interface? Are you getting? So let me just say this to you. Which cried in the night, Abi?
Yes.
And the baby died in the morning.
Yes.
What will you say? What will be the analogy? I will end this on this note. Which cried and the baby died in the morning. What will you say? I won't go further than this. There's a serious executive interference in what we are doing in this court. Simple. My Lord is helpless. The court is helpless. I won't go further on that. But I believe we are going to the upper court.
Yeah.
And I'll still continue to apply for CAN. Appeal for CAN. Yeah. We need understanding and focus. In line with admonition of Onyendu Mazi Nnamdi Kanu today. Because we're getting there. Victory must come. And must come soon. And let's continue to keep our eyes in the ball. Let us don't derail. That's what I'm telling you. Thank you for being here. And I wish you safe journey back to your various destinations, and God bless you.
Please, Barrister, before you end, I just want you to throw more light in a layman's understanding everything about the pending appeal court. You know, people have been hearing about appeal court. What is it all about?
Okay,
what is the appeal court all about?
Let me just come to a level that even the people at the market there will understand the language I'm using. These people filed 15-count charge against Onyendu Mazi Nnamdi Kanu, and the servers, and look at the charge and said, this thing is not a charge. It didn't disclose any offense, and it didn't show that Nnamdi Kanu committed any offense.
Okay.
From what we have, and also backed up by the law. We come to court and tell the court there is nothing here in this charge to warrant his further detention, or even to warrant the trial to go on. Because court's okay. And because of that, the court has not. We were saying we told the court that you have, because there is nothing here in this document to warrant him being tried. That as such, you have no powers to try him. Okay. So leave him, let him go back to where he came from. The court said, okay, let me look at this document to file. And the court look at it and say, okay, Chief Ozekhome SAN, we have seen that I agree with you that out of this 15-count charge, that 8 is not disclosed offense, it's true. I will strike them out. But 7, I will leave them. Now we went to Court of Appeal. And we are telling the Court of Appeal that there's no difference between the 8 left and the 7. And the 8 struck out and 7 left. That are the same thing. That the Court of Appeal should look at it and strike out the title. There's only 7. So now we go. That's all. We was struck out now. That's the end of the proceedings. No bail again. Nothing. We just go a free person.
Okay,
so is it clear to you for now?
Yes.
So that's what we're doing in Court of Appeal now. And it's coming up on the 11th of October for here. And I said, as I said, it is better for us to be there. You who have been coming to court, you understand the trajectory of this case. You don't need to be, you're no longer a lay person. You've been coming. All of you have been coming. If not because of this step we're taking now, the matter will be adjourned to October again. And October, nothing will happen. You will to adjourn again to this year. I hope you're getting what I'm saying. So let me understand that part. Because had it been the ruling was delivered on the merit today, we won't be talking about this. Today you'll be free. But it's now clear to everybody that So olugo guy mama party egbu agwara anyị mụta ha na-achọ. Ọ bụ ya nchọrọ egwu m. Thank you so much.
Thank you very much.